Hello, welcome back to Legal Opinions with Clementina. I remain your girl, Clementina E. Ukiri Esquire. I'm happy to see you again in this episode. The topic of discussion today would be the effect and the enforceability of a penalty clause in a contract agreement. When parties engaged into a contractual relationship, either to deal in goods or in services, there is this legal intuition to always anticipate disputes or situations that can result to dispute. And when this dispute is anticipated, the job of a lawyer or a prudent man of business is to consider modalities covered by the contract to cushion the effect of such dispute when or if they arise. While it is general to include the option to terminate a contract or to rescind a contract in the case of a breach, or the option to run to court to assess damages that have arisen, for the court to order an award of those damages in the cases of breach of contract, you would agree with me that when it has gotten to a point where you need to rescind or terminate a contract on the basis of a breach, that brings the contract and the entire transaction to an end. However, there is this interim modality that could sustain the lifeline of a contractual relationship, of a transactional affair, in such a way that it provides interim succor to the innocent party while punishing the party who is at default. That is where this very important clause comes into play, the penalty clause. The penalty clause is essentially beyond just cushioning the effect of a breach over the innocent party. It goes to the point of punishing the defaulting party. For instance, in a life scenario wherein party A and party B enters into a contract for party A to deliver 500 bags of cement, party B relying that on so date I'll be receiving 500 bags of cement for my construction or building project, and then party B goes ahead to engage the services of engineers and bricklayers, pays them mobilization fees to come to site on so date, only for party A to delay the delivery to a week after the due date. And party B had made arrangements for the use of those cement for a day after the scheduled date of delivery. In view of this, if party B's arrangement with third parties, the third parties have cancelled all their schedules, made themselves available at party B's site for the work, only to find out that there are no bags of cement to work with. And now party A delivers the bags of cement 1 week after the fact. All party B's plan were washed away, swept away like the sea water over the shore of the ocean. What is the remedy that lies for party B? You cannot say that the contract was not delivered entirely, but it has caused hardship on party B due to his involvement with third parties in view of his legal expectation from party A. Penalty clause. Now, the use of a penalty clause goes very simply thus: that party A, in the unlikely event that you do not turn in the delivery on so date as agreed, you'll be liable to pay me 20,000 naira, inclusive to the delivery of the bags of cement. For every day of default, it is 20,000 naira times the number of days. So now that you've defaulted with 7 days, 20,000 naira times 7 days. That will be my compensation in view of the contract. We must understand that a penalty clause in a contract of parties does not form a primary obligation on party A. When I mean a primary obligation, the courts, if called to interpret and enforce a penalty clause, will not look at a penalty clause as the initial obligation A, party A, owes to B, which can stand on its own. The initial obligation owed by A to B is to deliver bags of cement paid for. That is a primary obligation. It is only in the event that the primary obligation is breached or not satisfied in the manner the contract has stated, then the secondary obligation of the penalty clause becomes exercisable. So when a penalty clause is submitted to the judge or to the court to interpret and give effect, the court will satisfy itself that the penalty clause is not a primary obligation, it's a secondary obligation preconditioned upon the breach of the primary obligation. And then the court will also consider the fairness of the penalty clause in the circumstance. The proportionality, how proportionate is the penalty clause to the circumstance of the breach. For example, at party A has ordered 20 bags of cement to be delivered on so date, and there is a breach. Yes, we have the fact of that scenario. And then a penalty clause says, in the event that you do not deliver on the said date, you pay me 1 million naira per day. When the bags of cement, the 20 bags of cement, indeed is not up to the 1 million naira, even inclusive of the workmanship for the builders, that will be the second test for the court to uphold a penalty clause. How proportionate is it as a punishment and as a cushion to the circumstance of breach? The third ingredient that the court would examine over a penalty clause, examine whether party B has a legitimate interest to protect. Now, the question would ordinarily be, if there is a contract between parties and then you breach something, that gives me a legitimate interest. But that is not the case. The court will always look beyond the wordings of the contract to establish if indeed the penalty clause protects a legitimate interest. I understand that this explanation may run a little bit contrary to the doctrine of the sanctity of contract. But even in contracts, signed by parties who would agree in some circumstance could be illegal, and illegal contracts will be void by the court. That is not to say penalty clause is illegal, but for it to be enforceable as a secondary obligation arising from a breach of contract, then there should be a legal interest that the party who sought to claim on it must have. The initial scenario we painted, when party B had made arrangement to utilize the 20 bags of cement, is a good example of a legal interest. When party B has set things in motion in expectation of compliance from party A. So that is a legal interest that should be protected. But in circumstances where party B merely wants to store the bags of cement, and this intention is made clear, is known by parties, or even contemplated by the contract, that when you deliver 20 bags of cement, you will store it here for me. Another 1 month, I'll order 20 bags of cement, you deliver, I will store it here until I have 200 bags of cement, and I'll be buying 20 bags of cement every month. If there is a breach of delivery at a certain time, the legal interest to protect, you would agree with me, has not arisen. So the court is going to put these ingredients together to decide whether or not to give effect to a secondary obligation, being the penalty clause of a contract. Now, the advantage and the usefulness of a penalty clause cannot be underestimated, because it keeps parties on their toes to comply with the terms of a contract. For instance, if you say, oh, if you do not deliver so time, you pay 20,000 naira per day, I wouldn't want to incur such costs on me, so I will rush to ensure that I comply with the basic terms of my contract. So, my law-abiding audience, I would encourage you today, I would advise you today, that for you to enter into any form of contract or transactional relationship, consult a lawyer, a business lawyer, a dispute resolution lawyer who anticipates the likelihood of disputes in transaction and plans against such, and reliefs to cushion you contained within the contract. You can tell where you start, but you cannot tell where you end in relationships, and such is life. Thank you for coming back. I'll see you next time, and bye for now.